Hello, I'm Dave Creek, Chair of the GLVAR MLS.
Hi, and I'm Georgia Purpura, Vice Chair.
On Monday, July 9th, two new MLS statuses will go live. The under contract show and under contract no show. The current contingent and pending statuses will be no more.
As a part of this transition, there is a potential for agents to unintentionally create liability for themselves, their clients, and their brokerage.
We are here today with GLVAR's General Counsel, David Sanders, to discuss ways MLS participants and their brokerages can reduce liability when using the under contract no-show status and when they entertain so-called backup offers.
Hello.
David, does an agent need a seller's permission to change the MLS status to under contract no-show?
Georgia, there's no statutory requirement under NRS 645 or NAC 645. MLS rules and regulations also do not require the seller's permission to change an MLS status. That being said, it is highly recommended that participants secure written authorization or confirmation of any MLS status change to avoid potential future liability. Please note that this MLS status change are different from the requirement related to accepting offers, which does require written authorization on a real estate division issued form pursuant to statute.
Is there a specific form that should be used, or is an email enough from the seller?
Dave, state law doesn't require the use of a specific form, so email would be sufficient. However, I would avoid text messages and telephone calls because you will want a written record with dates and times from a seller acknowledging the change should litigation occur in the future.
Could an agent use the MLS change order form in this situation?
Georgia, they certainly could. There's no requirement to do so, however. Participants should talk to their brokers to determine if there is an internal office policy as to whether you use the change order form or if an email is sufficient.
Let's discuss the so-called backup offers. What is a backup offer?
Dave, at present, I don't believe this term is defined anywhere in the MLS rules and regulations, nor is there a clear legal definition of the term backup offer. With that being said, I'm not giving you legal advice, and this is not the official position of GLVAR, but I understand a backup offer is one that if the first offer the seller received does not go through, for example, buyer can't get financing or any other issue, the backup offer would be the next in line for the seller to review and respond to.
Could the seller be in jeopardy by having more than one accepted offer on the same property?
Yes. Not only is the seller under contract to sell the property to two different buyers along with the associated liability therein, the seller's agent and the brokerage may also be liable as well. I'm aware of at least several situations where sellers' agents have had to come out of pocket to the tune of tens of thousands of dollars to resolve such situations in the courthouse. Agents should be cautious when dealing with backup offers.
Does a seller sign a backup offer?
When handling backup offers, Dave, participants should be very careful to not allow their clients to unintentionally accept the backup offer. Then you'd be in a situation where you have two offers on the valid property. So you need to really speak to your broker. Brokerages may have specific language, for example, an account offer to use when you have a backup offer, or they may have an internal office policy on how to address that. So speak to your broker.
What expiration date does a buyer put down on a backup offer?
Georgia, I would suggest including an expiration date in your backup offer for a variety of reasons, including one, to manage buyer expectations, and two, to avoid a scenario where you have two offers being accepted on the same property. What that date should be, however, is something that you and your broker should discuss and decide because it's going to depend on a variety of factors, including the current state of the market.
For best practices regarding these statuses, participants should speak with their broker to avoid potential liability.
The two new MLS statuses, under contract show and under contract no show, go live Monday, July 9th. Thanks for watching.